Morning, everyone on the Zoom. It's nice to see you. I can see most of you anyway at one time. Hi, this is Dirk Draper. I'm the president and CEO at the Colorado Springs Chamber of Commerce and Economic Development Corp. And we're very appreciative you join us today for our virtual Chamber Connect. By delivering this virtually, we're continuing to do our part to keep our community safe by delivering events and programs virtually. We continue, as do you, I'm sure, to closely monitor the evolving pandemic and how it affects how we do business, including delivering events and programs like our Chamber Connect programs. As you know, the current guidelines from the state is there'll be no gatherings at this time of more than 10 people, no live gatherings. And so until this changes and conditions allow, we'll continue to refrain from physical gatherings of members. All events that the Chamber and EDC does through June 30th will be virtual like this, and we'll continue to we'll continue to evaluate that as conditions emerge and guidelines from the state and county health department develop. Our topic today is safer at work, mitigating employer liability, and I'll come back to that in just a moment. I will tell you that as our topic next Thursday is about mental health. And the topic is Know the Signs, Protecting Your Family's Mental Health Post-COVID-19. Our speaker next week is Dr. Laura Anthony. She's a child psychologist at Children's Hospital, Colorado. And during that time, among her topics will be maintaining stability in your households during COVID, signs to be watching for in your children about their concerns, their emotional reaction to COVID, and also then what families can do to help with homeschooling and adjusting to the new education system that families are working through right now. That's next Thursday. Back to today. First thing I do is let you know there will be an opportunity in the program to ask questions and ask you to use the chat line, post that to everyone. The chat button, if you're not familiar with it, is the top or bottom of your screen, depending on how you're set up. Scroll over that and you can see names there, and post your questions there. We'll field those to Julia at the end of the program. I would ask you, if you haven't done this already, to rename yourself on your screen so the speakers can see who you are. Right click on your image and you'll see the rename option, and go ahead and do that. Identify your name and your company that you're affiliated with. And the last thing I'd say is we'll do some networking at the end of the program at about 12:30, and encourage you to stick around for that, and just a way to connect virtually with others in the business community who are on the program today. Now I'll turn to our sponsor for today, Jenny Vinatari from BBSI. They're the sponsor of our Chamber Connect today. Jenny, it's up to you.
Hi, good morning, everybody. Jenny with BBSI. We are a local high-touch team of subject matter experts advocating for the small to mid-sized business owners in the areas of HR, risk management, talent acquisition, payroll, workers' compensation. So if you're experiencing any challenges or have any questions in any of those areas pertaining to your company, please feel free to reach out to us. We'd love to see how we can help. Thanks, Dirk.
Thanks, Jenny. Thanks for sponsoring today. So one of the interesting things that's emerging out of the pandemic and the conditions we face in the business community has come as we get past the immediate response and we start to talk about recovery. There's a lingering issue of the uncertainty about liability exposure, whether that's with your employees or with customers or with vendors. What is your liability as a business owner and leader towards about that risk? As we start to return to the office, employers will have new policies in place that protect safety of employees. We've done that at the Chamber and EDC, and I think we've shared that through our website and through newsletters. And with those policies come new ways of working. During today's Chamber Connect, we'll learn how to proactively address those personnel issues and ensure you're putting together the best procedures to mitigate that risk for you and your business. Our speaker today is Julia Paris. She's an attorney with the Employers Council in Colorado Springs. And I can tell you from our personal experience, we've gotten excellent advice from Employers Council through the years. We're very happy to, very pleased with the work we've done with them. Julia, as you'll unmute, I'm about to turn the mic over to you and have you talk to us today about mitigating employer liability. Julia,
Sure. Thank you, Dirk. I appreciate that. Hi, everyone. I'm going to quickly share my screen so that we can, and then I'll kind of introduce our presentation today. I hope everyone can see that. If someone cannot see it, the title is Employer Liability in a COVID World. If you can't see that, please let us know via the chat function, and we'll figure that out. So as Dirk mentioned, I'm Julia. I'm an attorney with Employers Council. And we serve as a membership organization, and members who pay an annual membership fee basically call in and get call a lawyer services when they're having legal issues or HR issues, and we provide advice on a variety of topics. Because of the nature of what we do, we often can talk about trends that we're seeing in terms of employer concerns and things that are happening out there, how they're manifesting with employees. And especially now, I'm happy to speak to a lot of the concerns that we're seeing from employers and how we can talk about that. We focus on employer-employee relations and the legal liabilities there. So that's the scope of this presentation. It won't go further into business liability and that type of thing, and we'll primarily focus on that employer liability. So when we get in calls lately about from employees who are concerned about the different types of liability, they tend to focus in a few areas. And these are the primary risk areas that we see in the climate that we're currently in. We have a lot of uncertainty right now in the legal area just because this is not a situation that a lot of the laws that we have were really contemplating. So it may be that we see some legislative changes or some regulatory changes or even just changes in how things are applied by different agencies and the courts. So when I'm talking today, I'm talking from this moment in time. There could be changes even 20 minutes from now in terms of what we see coming down from different agencies and some interpretive guidance there. So I'm going to just generally talk about certain areas where we see greater risk for employers who are bringing employees back after furlough or stay at home or any of those types of things. And those tend to be focused in the areas of OSHA compliance, workers' compensation. We're getting a lot of questions about that. And then, of course, everybody's biggest fear, just the general negligence suit, and how will that affect us, and what can we do to avoid those types of claims. There are also some things I'm going to talk about because they may be getting lost amidst the sense of urgency and just the general feeling that this is an emergency situation. Some of the traditional employer compliance areas that we focus on, they're still around, and so we don't want employers to lose sight of those. So I'm going to cover some of those just general heads up type topics that we want to remember to keep in compliance with, even while we're dealing with all of these other crazy things. So starting with OSHA, for those of you who don't know, OSHA is the Occupational Safety and Health Act, and it's administered by the Occupational Safety and Health Administration. So OSHA and OSHA act very close in terms of how they're said. So OSHA requires employees to provide just generally a safe work environment. The actual language from the act is up here. But that's where I think in this current climate, you'll see the greatest liability in terms of compliance with this. We've had a lot of questions as to whether or not possible COVID exposure is a reporting event for OSHA. And generally the guidance from OSHA has been that it is. But that may not be as earth-shattering a statement as it sounds, just because of how OSHA requires reporting for incidents or exposures that happen in the workplace. Basically, their criteria, and this hasn't changed, this is the same criteria they use for all of those incidents or exposures, is that you have a confirmed case of something, and that it can be traced back to exposure in the workplace, and that it also meets the other OSHA criteria, that it results in a death or hospitalization or basically treatment beyond first aid. So none of that is new. And for those of you who've dealt with OSHA before, that should sound pretty familiar. Where we're seeing some confusion and hesitation is, how does it apply now? I mean, this really isn't something that was contemplated with OSHA. It's primarily for those workplace injuries and just general safety precautions, and that's a lot of what it deals with. So I think the biggest safeguard here is that causation is going to be very difficult to establish in the context of OSHA reporting, or liability even. When you have something like COVID that's just everywhere, it's going to be difficult to tie that someone testing positive for it, tie that back to a specific incident or exposure in the workplace. I mean, some obvious defenses come to mind, and talking to employees, like, did you go to the grocery store? Because it might have been there. How do you know you got it here? And that's I think, some of the guidance that we've seen from OSHA, is that will be the kicker in terms of whether or not you report it, whether or not there's any liability there, is how how directly can you tie that potential exposure to an actual positive test. OSHA has issued some guidance on how to interpret the act with regard to COVID. It's actually pretty helpful. It's pretty substantial, so I didn't really get into it too much, but I did put the link here on the website, or on the slides, so that you can look at that. And I do recommend it, because there are some additional things on there that I didn't even think about initially. And then when I started reading through the guidance, it became clear that those might be areas of concern, and areas where you should look at some potential mitigation. One of the things that we see with OSHA in terms of employer liability is retaliation. And this, I think, could be one of the biggest areas within OSHA compliance where we might see some risk as employers. And that those retaliation situations happen when a worker complains about general unsafe conditions and then is terminated. And even if it's not even if it's not directly caused by their reporting those, it can look bad. Basically, if it's too close in time, it opens the door for an employee to file an OSHA complaint, which can get ugly if there's anything to those allegations. And it's just something that you don't want to have to deal with as an employer, because it can be a big inconvenience. So one of the things that we're advising is, don't necessarily shut that down. If employees are talking about their concerns over ventilation or sanitizer or mask wearing, don't shut that down. Listen to their concerns, talk to them, try to mitigate those, and just be watchful of how you time disciplinary actions or potential terminations with those employees. And it might be worth a call to legal counsel, or whoever you get that type of advice from, if you are considering termination from an employee who's been vocal in this area, just because it can lead to those retaliation complaints. One of the things too, and this is true for all the topics I'm going to talk about, this is a really good time to check your EPLI policy. That's the basically your employer liability policy for the actions that you take that could result in charges or lawsuits or fines or anything like that. Those policies are all different, and I can speak a little bit to what's generally included, but there are many carve-outs, and there are many different levels of coverage. So this is a good time to go through and look and see, are you covered for OSHA retaliation complaints? Are you covered for wrongful termination? What are your negligence carve-outs? Those type of things. Take a look at that, because that could help give you peace of mind, or maybe cause you to reevaluate what type of policy you need if you need some additional coverage. This is one of the things that I was surprised to see, but when I looked through the OSHA guidance, thought it was worth bringing up. One of the concerns hadn't occurred to me was the use of all of the chemicals that we are using and that we're being advised to use in the workplace you certainly need to do that, that could cause some reactions in people. This could cause some safety issues. I mean, if you clean something with some very heavy duty bleach based cleaners and you don't ventilate a room, you are potentially opening the door to some OSHA violations. So just something to keep in mind. OSHA has a lot of information about how to avoid those types of issues and stay in compliance. So it's definitely worth a visit to the site and taking a look at this guidance in terms of avoiding any risk under that act. We've also had a lot of questions about workers' compensation and how that's going to be affected by coronavirus. Initially, I think it's becoming clear. Initially, it wasn't clear as to whether or not those claims might be covered. We've had some additional communication from some of the larger workers' comp insurance carriers. And basically the answer is the typical legal answer, it depends. These are case-by-case determinations as to whether or not someone can get workers' comp if they get exposed at work or if they get COVID from work. Generally, we want coverage here as employers. This reduces our risk from individual private lawsuits. So we prefer, it's kind of a limit. It's also a no-fault system. If someone shows that something happened at work and they were injured or can't work as a result, then it's just an automatic. We don't get into who did what, and it really does cut off that liability later on. So it's a positive thing if the carriers decide to cover these, but again, the same with OSHA, where the issue is going to be causation. And that's just going to be too difficult to show in a lot of cases for them to grant those claims. So what we have heard is that certain industries, workers in those industries might be able to get workers' compensation if they have a positive test due to their job. And those are going to be primarily the healthcare workers, people in the medical field. That's what we've seen so far. I have wondered to myself, given some news reports, if there might be certain cases, for example, the meat packing plants we've seen, where it's easier to tie that specifically to a workplace. When you have these rural areas and there are no cases except for these plants, they may have to cover it in those cases. That's one of those things that remains to be seen, but I think is a possibility. But they have said that certain medical fields where there is just exposure by the nature of what they do, they're more likely to cover those claims, which is a good thing for the employers because it does limit that later liability. So this, everyone, I'd like you to meet your employee's future attorney. And don't worry, he's a great guy and you're going to love him. No, that's tongue in cheek in case that wasn't obvious, but I saw this and I had to include him somewhere in this presentation because I think that's how we all see it as employers. This is what's coming down the pike, right? We feel vulnerable now and people are waiting in the wings to file suit or bring a complaint against us for something. So, there may be some liability here. There always is. As you know, if you do business, if you have employees, you have risk. That's just kind of one of the costs of doing business. And there are ways to mitigate that. You're never going to get that risk down to zero. So a lot of times what we do at our organization is help people be aware of the risks and the likelihood of the risk, what the possible costs could be based on various decisions, because then they can make those decisions with the right information. Risk shouldn't cripple your decision-making ability. It's a factor, but it's not always the determinative factor. Sometimes other factors are more important and they shouldn't be discounted. So the good news is, despite the happy lawyer over here, is that I think that a lot of the potential exposure is actually is something that we can limit, and it's something that we can limit just by following some basic guidelines. Now, I realize that some of the guidelines that are out there may be more difficult for some employers to follow, depending on the nature of what you do, the nature of your facility. All of those things are complicating factors. So, just generally, in order for someone to have a negligence claim, a few things have to be present. You have the plaintiff has to be able to show that there was a duty that was owed to them by the employer, that the employer breached that duty, and that there's a causation between the breach of that duty and some injury that the employee suffered. So that seems simple enough, but I think it's actually going to be more challenging to show that in this world. And the reason for that is the same reason I was talking about when it came to OSHA and workers' comp, and that's that causation factor. With something like a pandemic. We have community exposure so many places, and there's so many unknowns in terms of exposure and in terms of vulnerability. It's really going to be difficult for someone to show that direct line of causation, that some action or taken or not taken by an employer was a directly resulted in that employee testing positive or becoming ill. I think that's going to be tough for a lot of people to show. That doesn't mean they won't try. We all know that, right? I mean, again, just by virtue of existing and doing business, we could receive a complaint or a lawsuit. And it's very easy, honestly, for people to do this. That's the nature of our legal system and the nature of our regulatory system, is that those avenues are open and they're not terribly burdensome or difficult. So we might get some nuisance complaints. We might get some nuisance suits. And it is irritating and it can be costly to shut those down. But again, that's one of the costs of doing business that may happen if you follow a couple of practices and documentation. You're going to be in a better place when it comes to shutting those down, so that they result in less cost to you and less inconvenience. And I think, even if employees are able to show that causation and that direct line, there are some safeguards that you can put into place in terms of how you're bringing them back, the kind of environment you're having people work in. All of those things, the way that you do them could mitigate that risk a lot. I think the biggest safeguard you have is to follow just the general guidelines that are out there from the public health departments, from the CDC. The Safer at Home order has a lot in there. If you're following the generally accepted guidelines out there about what you're supposed to do, how to often to clean, the health precautions you're supposed to take with your employees, that's going to be a big defense. And not only doing those things, but documenting that you've done them. And as an attorney, I can tell you that's huge. Many employers do things right, but they can't show it when they need to. And that can be a big vulnerability. So it's important to, as you're following those guidelines, make sure you make note of this, that you're communicating with your employees, you're telling them what to do, that there's a record of all of this, that you're giving this information, giving them these options, cleaning, doing all of these things. Your best bet is to make sure that you keep track of that and that you're able to show that you did it if someone later calls your actions into question. So with that in mind, I am going to go over Safer at Home a little bit. Now, I'm sure that most of you have read it. It's dense. It's dense, and it has a lot of specifics for different types of industries. They're obviously, these are the high points, and these are some very big generalities. And I'm happy to try to answer some questions, but again, it's new. I think there's going to be some additional guidance that comes out to explain some of this. So this is just general stuff that you can do and that you should do under this order. So basically, the order lays out who can open and when. And again, most people here probably have read through that and know how it pertains to their business. But there are a lot of limitations. Critical businesses, critical government functions, those are and have been going. And they're dealing with different things because they've been operating this entire time. If you're bringing people back, you're bringing employees back into a very different environment with a lot of restrictions. We've had a lot of questions about how do I bring back 50% of my staff? Which 50%? Do I stagger the shifts? How do I do that? Those are very case-specific questions. Some of them, we can answer some of them, but a lot of them are going to be based on the nature of what you do and the nature of your facility, your actual physical plant. Those are going to affect a lot of these things. I think keeping in the spirit of the order is going to be crucial in terms of avoiding liability here. Show that you're trying. Again, that documentation is going to be very important. So I have some of the high points that I hit under the rules in terms of how we should be operating as employers. And basically, the big ones are here. There are more specific ones, again, within the order and even within just general safety precautions in your own industry, depending on what it is you do. But employers essentially they do need to be requiring and providing masks or other PPE that may be beneficial. You may have different needs, again, depending on what you do, but masks are kind of a basic and kind of the floor of what we should be providing and requiring from our employees. There needs to be signage, and there needs to be ventilation in the areas in which you're bringing people back in. That's one of the big complaints we're hearing is you can't shove people back into the same offices they were in necessarily. You may need to make some accommodations in terms of workspaces. I've heard some very creative ones from different employers we work with, and I think this is a great test of how flexible we are and how creative we are and good at thinking outside the box in order to meet some of these requirements while still accomplishing our overall business and organizational goals. Maintaining social distancing is a big one. And those are areas where we're seeing employers reporting complaints from their employees is I'm being required to sit too close to the person next to me. That I think could be a big spot of vulnerability as employers. I think we need to make sure that we are allowing people or requiring people to maintain that social distancing and listening to employees who say, hey, this isn't happening. That's going to be really important, is showing that you listen to those complaints and you respond to them, and then being able to document that as well. Cleaning and disinfecting, encouraging remote work. That's still the baseline. The order allows businesses to open and bring employees back, but the overall spirit is that we're still supposed to be encouraging telecommuting and remote working wherever possible. I know we're still all remote, and we don't have a return date in mind because we can do everything that we do remotely. So because we don't have to be in the office to keep our doors open, metaphorically, we're not going back to the office. We are respecting that. So I think that's key. This shouldn't be a return to business as usual. This is only for the employees who need to be at the facility to do their jobs. There are lots of employees like that. Remote work doesn't work for a lot of people, but where it does, it's important to keep that in mind as a priority option. We need to be cleaning and disinfecting and following those general guidelines that the CDC and the public health departments have put out about how to do that. Requiring sick employees to stay home. That's going to be a big one too. And letting them know that they are under that requirement and that if they have symptoms, they need to let you know and they need to stay home. We can't have the flexibility that we've had necessarily in the past where, if you have a cold, you kind of muscle through it. I think we need to be a lot more careful and a lot more cognizant and allow those employees, not only allow them, but require them to stay home when they report any symptoms, and that they need to communicate with the employers about that. One of the big ones too that we're getting a lot of questions on is the symptom monitoring. Employers are supposed to be symptom monitoring for all of the employees they bring back. There are different requirements for employees who are bigger, who have more than 50 employees at a given work site. Those requirements basically are that you have to have these stations on your workplace. You have to be the one getting those symptoms, checking them off, taking the temperatures, doing all of that. I think if you're smaller, the way that we're reading the order, there may be some flexibility to have employees self-report and to have them do that themselves at their home, as long as they're communicating that and doing that. I'm not sure if that's going to continue. I think that may be a wait and see piece of this. We may see some additional guidance come from Colorado Public Health or the governor's office about that, and if that's allowable. There are some confidentiality issues and some ADA issues with that, and I'll get to those in a little bit, but businesses do need to be requiring and sometimes conducting the symptom monitoring. Also, one thing that's really important is the accommodation of what the order has deemed vulnerable individuals. And those are defined in the order. Basically, it's people with upper respiratory conditions, with immune issues, or pregnant women. Those people, we're treating them as though this is an ADA request, basically. So if they need to stay home, if the doctor has recommended that they stay home, then that's something that businesses actually are required to accommodate. Now, that accommodation isn't as onerous as you might think. Basically, the accommodation for people in this situation is going to be unpaid leave. So that it may be difficult in terms of maintaining your workforce, but in terms of extra expense, it won't necessarily be the case. It's not a paid leave that's required. It's an unpaid leave, as if it were any other ADA type accommodation. So this is, I get calls. I have a positive employee. I often say this used to mean something different. If I would get a call about someone having a positive employee, that's a great thing. Congratulations, that's wonderful. That's not the case anymore, unfortunately. Now I have a very different take when I get those calls, and I have very different things that I tell employers. So there are certain steps that we recommend employers take when they are notified that one of their employees has tested positive. Obviously, you need to follow the cleaning recommendations, again, from the CDC or the Board of Health. Those are going to be really important wherever that employee was. Where we get the most concern, though, is what do we do about notifying the other employees? Admittedly, we have some sort of duty to let them know they've been exposed, but we also have a duty to the employee who's given us this medical information that we need to keep confidential. The confidentiality requirements in the ADA and HIPAA, those are not gone. They are very much still in play, and my prediction is that when the dust settles and we come back to whatever the new normal looks like, people will look around and start to realize, oh, my employer wasn't supposed to share that about me, and they did, and had some impact. So now I'm going to need to file a complaint. We might see an uptick in those. So I'm cautioning all the employers to just be very cognizant of that confidentiality and of those privacy requirements, because they're very much still in play. So the way that we advise people to handle this, if they get an employee who tells them they tested positive, is to talk to that employee first, if you're able to, about who they generally work with, who they worked with recently. If there are other people they don't normally work with, but they did in that particular time frame, just get a list. You might realize as the employer or the supervisor that they've left some people off of that list. Go ahead and add them. Figure out basically who this person came into contact with for the week or two preceding that diagnosis. You only need to notify those employees that they came into contact with. And all you need to say is that someone was in the facility or someone was in the workplace who later tested positive, and you advise that these employees contact their medical professionals for advice. You don't need to, and you shouldn't let them know who it was. They might ask, don't tell them. If the employee themselves decides to later disclose that information to their coworkers, that's fine. You're not liable for that. But that information can't come from you. That still falls under the privacy and confidentiality piece of this. So you want to be sure not to communicate that and just keep it very vague as to who it was. And yeah, in some cases, they're going to know. There's no way around that. You're not liable for that. It's only if you deliberately or really even inadvertently convey that identifying information, that's going to be the problem area. You also want to have some idea about what you're going to require of these employees who test positive and the people at work who were exposed to them. Are you going to send them home? Are you going to have a minimum period of time? Again, I would look to the CDC and Safer at Home guidelines. There are pieces of that in there, but also you can add to that. You can make it more restrictive if you want to. It's going to be based on internal policy. You want to be sure, though, that it's consistent. You're applying it the same way to all the employees, not showing favoritism or anything that could open you up to discrimination claims. But a lot of that, in terms of how you require employees to come back to work, if you require documentation from their doctor, all of those things, that's going to be based on your own internal policies. So as I mentioned, all of those things are still in place. But not only that, not only the confidentiality piece of it that I was just talking about, ADA is still very much in play in terms of accommodation. And the way that we're seeing ADA play out right now is people who have an immune condition or a respiratory condition that makes them more vulnerable, or people who say, I can't wear a mask for some medical reason. Those are the two big areas that we're seeing. So we advise just following your typical ADA accommodation procedures. If someone has a note from their doctor saying they have an immune condition or an upper respiratory condition and they really shouldn't be at work, I would first advise, considering the stay-at-home the telecommuting or work from home, if that's an option. If not, again, you want to start that documentation and that ADA interactive process with them. And it may be, in a lot of cases, it will be that the only accommodation that's really viable is unpaid leave. And there are some guidelines around that. Again, I would advise talking to your legal counselor or whoever typically gives you advice in the employment realm, just in terms of how to structure that accommodation in terms of time limits, reevaluations, all of that. You want to be careful giving open-ended accommodations, because at some point you will need to reevaluate as to whether or not employment can continue if someone can't come to work indefinitely. With regard to the mask issues, we see a lot of cases where employees say, I can't breathe, I have asthma, I have something, I have anxiety. These things are potentially ADA issues that also need to be accommodated. So the EEOC has told us that in this pandemic, we're in what they call that direct threat territory, which means that some of the rules are different, some of the requirements are different. We've seen that in terms of taking temperatures at work and asking about symptoms, things that we normally really shouldn't do as employers, but those are relaxed a little bit because of the threat to safety. And the EEOC recognizes that, and it puts us in a little bit of different territory when it comes to the ADA. That being said, we have the right as employers to require masks. And we have the right to say, if you can't wear a mask, you can't come to work. Now, when we have an employee who says this is a medical issue, again, treat that as an ADA accommodation. Ask for the documentation from the physician or from whoever it is who gives the medical care. Why? Well, what is it that you can't do? Is there a workaround here? And then start that ADA interactive process. Again, in a lot of those cases, if they really can't wear a mask at all, probably the only accommodation is going to be unpaid leave. But we've seen some where the employees, I just can't wear a mask for more than a few hours. Well, that might mean staggered shifts, different length of shifts, or some sort of flexibility there with regard to working. There are also anxiety. I've seen this too. Some anxiety, if it's, I can't wear a mask. Okay, again, we're following the same ADA interactive process. But we do get calls about employees who are just too scared to come to work. And this is, I think, going to be a big issue going forward as we continue to bring people back. Many employees, they don't have necessarily a medical condition. They're not classified as a vulnerable individual under the Safer at Home order. They don't necessarily have something that would bring them within ADA, but they're just scared to come to work. And given everything that's going on, it's not entirely unreasonable that someone would be concerned. And that, I think, is going to be a very big gray area for employers. Many times there won't be any legal protections for these people. This may not give them protected status. You may not have to accommodate that if it's not related to a medical issue. So you have to decide as an employer how flexible you're going to be. Again, I would advise consistency here. And the reason for that being that you don't want to open yourself up to any discrimination complaints later. But honestly, for the most part, someone who's just concerned really doesn't have a lot of legal protection. Again, if you can allow telecommuting or remote work, that's encouraged by the Safer at Home order, and we're really required as employers to think there first to allow that whenever possible. If not, then someone who is just afraid to come back to work, they may not have any legal protections, but I often give the advice that just because you can do something legally doesn't necessarily mean that you should do it as a human. There are different realms. So we can talk about legal requirements and are you really required to accommodate this person or required to let them stay off of work forever? No, you're not required legally to do that, but there are some other considerations just as humans and as employers. So it's important to think about in advance how you're going to handle that and what types of accommodations, if any, you're going to allow your employees who are just nervous about coming back. So this is the area where I do see in the future, I foresee some upticks in complaints. And I think I've actually heard, I think the EEOC recently said that they have seen some increases in complaints that have been filed, not necessarily charges yet, but complaints because of how layoffs and furloughs and reductions in hours were done. So I think again, as we're looking at those considerations, are we furloughing? Are we laying off? Are we reducing hours? Are we switching shifts around? Are we terminating? All of those things, it's important, again, to be cognizant of those protected class discrimination issues. Make sure that you're using business reasons that can be well documented and that can be defended later in terms of how you're making those decisions. Seniority is always a safe one, honestly, in terms of bringing people back. It's kind of an objective, neutral. It's not necessarily tied to age even or anything like that. It's a safer one in terms of how you bring them back. You just want to take a look at the effects of your actions and make sure that they aren't tied, even inadvertently, to some sort of protected class status, because that will help in the future in terms of your ability to defend any charges that get brought. You also want to be careful when you bring employees back about possible stigmatization. Again, we're not really sure at this point what type of protections in terms of the ADA someone with coronavirus or COVID would have. Typically, viruses like the flu, they're not covered. They're not given ADA protections. But again, this is a new environment, and we don't know at this point. So it could be that this becomes a protected class or something coming out of it. We want to avoid allowing stigmatization of people who've had COVID or who have symptoms. You want to be careful of that. Also, just due to the nature of how this virus arose, a lot of people are tying it to certain areas of the world, certain races. We want to be careful, particularly with Asian employees, that we don't allow stigmatization there either. Also, keep an eye on your terminations and your discipline, not only for discrimination, but for other, wrongful termination issues in terms of, for example, I mentioned the OSHA retaliation. Keep an eye on that. Again, always with every termination or discipline, you want to have a good record. You want to have documentation that's done the right way in terms of showing why you're taking a certain action, how it's based on business reasons and non-discriminatory reasons. So it's important to keep doing that, especially now. So some other areas that I wanted to highlight, because we have been getting a lot of questions, and even though we're bringing employees back, these things could still come into play. Our economy is definitely not stable right now. We may see additional layoffs and additional furloughs and those types of activities. One thing to keep in mind is the FFCRA, the Families First Coronavirus Response Act. This is the act, I'm sure you've heard about it and probably have interacted with it, requiring employers to give both emergency paid sick leave and, in some cases, expanded FMLA to different employees who might meet different types of criteria. It's a strange act. It's a strange act, particularly in the FMLA realm, because it expands FMLA to include a new criteria, but it also makes that criteria paid, which, if you've worked with FMLA at all, is a complete departure, and it's making things a little bit more difficult. But it's important to be aware of this law, because the default is that employees are covered by it, especially the first prong, that emergency paid sick leave. So just make sure you're aware of it, and that you're cognizant of it in case employees ask for this leave. There are a lot of good resources designed to help employers navigate these waters. The Department of Labor has some great frequently asked questions. They're adding to them as we go. The IRS, surprisingly, has some good guidance that supplement that. So just take a look if you're not familiar with this law, because we have already seen a couple of Department of Labor enforcement actions against employers who did not provide the leave that they were supposed to provide. So I want everyone to avoid that. So just make yourself aware of this law. And again, ask your legal counsel or whoever gives your employment law advice about that if you run into specific situations. And this really isn't necessarily a liability exposure area, but unemployment is a big concern for a lot of employers in terms of all of these claims and all of these employees who are filing, and will this be charged to me? If your claim is COVID related, you're not going to get charged, except if you are a nonprofit or government entity who doesn't pay into the fund, and then you will be charged. It will be against your account for 50% of those claims. There may be some relief. I have seen some some legislators, I would say, proposing some relief for those organizations. But as of right now, that's the way it stands. But one thing to keep in mind is that the way that unemployment is structured right now, because of that extra $600 a week that the federal government is giving out, many employees are making more on unemployment than they will be when you bring them back, which means that when you contact them, you might face some reluctance. I don't want to come back. I want to stay on unemployment. This is a question we're getting a lot. So it's important to know that if you contact an employee who's on unemployment because they're furloughed or reduction in hours, and you try to bring them back, you offer them work and they decline it, that is something that you are supposed to report to CDLE. They do want to know, because simply choosing to stay on unemployment is not supposed to be an option. It's not legally an option if you have work for that employee to do. And CDLE feels so strongly about this that I just checked their website recently, and they have now added a giant button on the employer piece of their unemployment website where you can report that online rather than waiting on hold for hours and hours with everyone else. So just something to keep in mind. However, one caveat to that: in the Safer at Home order, the governor did order CDLE to come up with ways in which vulnerable employees will not be penalized. They will not lose their unemployment because they're asked to come back to work and they can't, because they still have their whatever condition it is that makes them that vulnerable individual. So that's also something to keep in mind. However, for everyone else, definitely report that to CDLE. There may be some wage and hour concern and some liability there, depending on how things like furloughs and hours reductions and all of that were handled. Again, that's something that will, in a lot of cases, will be covered by your EPLI policy. And again, this is a good time to go check that and see if you have coverage for wage and hour issues. I don't think that's as big an issue as some of these other areas, but just something to keep in mind. NLRA, this goes along with the OSHA requirement, the retaliation issue. You have to allow employees to talk to each other about problems they're having at work, about things they see you doing that they don't think are right. This feels wrong to a lot of us, but you want to be careful cracking down on that employee conversation and communication, because it can result in an NLRA issue. The WARN Act is also something that may be getting forgotten by some employers. This is only applicable to you if you have more than 100 employees. But what it does is it requires you to give notice to certain people if you plan layoffs or plant closures. And there are a lot of different ways of calculating how you're affected and what your requirements might be and when you might be pulled into this. But it's something to keep in mind if, looking down the road, you see that you might have to lay people off in large quantities. You might have to close your doors. Depending on how big you are, you might be covered by WARN, and you might have to give some advance notice. Initially, when this happens, there is a piece of WARN that says if it's unforeseen, if it's not possible, an emergency situation, then your notice requirements are reduced. And that's what a lot of employers were relying on to get to not be in a state of non-compliance with WARN. However, we've been in this situation for a while. I predict that that won't be a defense for too much longer. So, for example, employers who've gotten those PPP loans, if they were only keeping you afloat for a while, and you predict as soon as that 8-week period or whatever it is has run out, you may have to lay off, it's a good idea to keep WARN in mind and to make any notifications that you have to make. If you end up not laying off, that's fine, but it's better to make the WARN notification if you think there's a possibility you might lay more employees off. So the takeaways from all this are basically just to follow the rules, follow the workplace rules. I think that's going to head off a lot of liability in the areas I've talked about. So that, education on hygiene, allowing breaks for hand washing, the social distancing and ventilation are going to be important, encouraging that remote work, not having meetings, not allowing the break room type of activity, and then the accommodation of vulnerable individuals and the symptom monitoring. Those are going to be the biggest things. Obviously, these are the high points. They may not meet all of the minutia in the Safer at Home order. So I would strongly advise going through that, looking for your industry, seeing if there are any additional requirements, but also really looking at those hygiene and workplace restrictions and requirements, because that will be the biggest way in which you can defend yourself against any suits or complaints or charges that come down later on. So that's all I have today, and I think we're going to open it up for questions, and I'll be around for a little bit if people want, because I know that there probably will be questions because this is a very uncertain world. But I encourage you all to keep in touch again with your legal counsel or your HR advisors, just because we're in such uncharted territory, but we're all in this together, so we can share wisdom and we can share best practices. And best of luck to all of you as you continue to bring employees back. Thank you.
Thank you, Julia. I'm going to stop sharing. Oh, you stopped. Thank you.
Oh, sorry.
We wanted to see your beautiful face to answer the questions. So first, before I start asking you questions from everyone, which thank you everyone for submitting your questions, I wanted to ask you if you could give me a 2-digit number, because we want to do a raffle for 2 Concept Restaurant gift cards.
Sure. Okay. So and you mentioned this before. I should have been thinking of one, but I'm just going to randomly pick 27. That was a good year.
Okay, awesome. Well, we'll announce that raffle winner here in a couple of minutes. If everyone could please rename themselves too, so we can call you out as the winner, that would be wonderful. So we had quite a few questions, and I don't know that we're going to get to all of them, but you and I were going to record the answers to the rest of the questions tomorrow. So we'll get those to everybody if we can't get to all of them. So the first question is, there is momentum in Colorado and nationally for providing presumptive workers compensation coverage for essential workers. 14 states have enacted presumptions. 8 states are negotiating bills in their legislature. What is your view of this issue and the likelihood of it being implemented in Colorado?
I think it's a fairly, there's a good likelihood, honestly. Again, the landscape we were working in before was based on our pre-COVID world, and that was very different from this world in terms of illnesses and pandemics and how things are transmitted. I think this is giving us a very different perspective and a very different future because of what we are learning scientifically about how this virus is transmitted and how it affects people. So I think Colorado is usually pretty good at being at the forefront of a lot of those things, and we're usually pretty progressive in that area. So I predict that we will probably join that group. I could be wrong, but that's based on what I've seen previously and a general sense of how we operate. I think the likelihood is good.
Perfect, thank you. Is there an official timeline for the restaurant business regarding the opening of their doors in the gathering of people?
I have not seen one. I've been checking, but I have not seen anything like that yet. I know there's a lot of concern out there because I've gotten reports of people congregating outside of restaurants rather than inside. So I'm not sure how much good it's doing, honestly, at this point to keep those closed down. But I do not have any knowledge at this point that hasn't been released. I don't know of any opening date at this point. We're still restricted to the takeout and delivery and curbside and all of that. And I don't know of any date that's been released for that reopening.
Okay. All right, this is another long one. Even though the topic was mostly about employer-employee relations, how about a situation where a company is putting employees into a conflict environment with customers who are either scared or think everything is overblown and don't seem to care about mitigation? Are there guidelines to what an employer can tell or not tell their employees about how to work in that environment?
That's a great question, actually, because we are seeing that. I mean, there's a whole host of, there's a wide spectrum of how people are interpreting the restrictions that we're under. as an employer, you do have the responsibility to safeguard the workplace of your employees. So if you know you're getting irate customers, and if you know you're getting people who might put your employees' safety at risk, it's important to address that. And that can be addressed from a policy standpoint. So let employees know if they're allowed to have customers removed. If you have a mechanism for doing that, I would make it clear to customers as well. You have to wear the mask. You have to have social distancing. If you don't do these things, you cannot come in. You cannot patronize our business. That the safeguarding of employees, that's only good. The policies are great, but it's only good insofar as you enforce them or allow your employees to enforce them. So, you know, we don't want to get into a situation as business owners where we're having people forcibly removed from our businesses, but I think it also does make it clear to the public that we are protecting our employees. That also makes it clear to, say, EEOC or OSHA or a court later on down the road that you prioritize this enough to take action against those patrons and visitors who did not respect the safety of your employees.
Thank you. An employee's hours were greatly reduced and they are receiving unemployment, also qualifying for the extra $600. If the employer calls them back but still is not giving them the same number of hours as before the pandemic, can the employee still qualify for some UE and or the extra $600?
Yeah, that's a good question too. So if they have an open unemployment claim, they're eligible for the 600, and that the value of that claim doesn't matter. If it's anything, then they get that extra federal amount. In terms of whether or not they are still eligible, that's going to depend on how many hours they're working. So the unemployment qualification, if you are working to receive it, is basically that you are working 32 hours a week or fewer, and you are making less than your weekly benefit, not including the 600, then your weekly benefit would be. And if you meet those criteria, then you can still qualify for unemployment. Now, if you were on unemployment due to reduced hours and your hours increase, you will probably see a reduction in your benefits, but that shouldn't be necessarily a reduction in overall wages because it's really just a matter of who's paying it. Is your employer, is it the state? So yes, that will change it, but if you meet those criteria still, you'll still be eligible for both the unemployment and that $600.
Okay. Can employers offer lesser hours if the employee is close enough to qualify for unemployment and still work comparable hours, i.e. employees that are offered part-time positions but the employer can't re-offer full-time?
And what I caution against is you can change hours, you can change shifts, you can do all of these things as long as you have a business reason for doing it. What I caution people against is trying to work the schedules to accommodate unemployment qualification. So you don't want to ever be accused later of gaming that so that that person would qualify for benefits when there is no real business reason for doing that. So you have a lot of flexibility in terms of reducing hours and furloughing and doing this and doing that with your employees, but make sure that you can justify that it's business related and not just to help someone qualify for unemployment. I think that's going to be key in avoiding issues with the state.
Okay. How can you conduct the symptom checks without violating HIPAA?
HIPAA is about communication of that data. So you can take the data as the employer. You can take the temperature, ask them about symptoms, all of those things. You can't communicate that to anyone else. So that's where it can be difficult, and it's very important how you structure the symptom monitoring. You want to make sure, if possible, that it's not someone's supervisor who's doing it. That's actually just an ADA issue. You don't want supervisors having medical information. It's better if it's done by someone in HR or someone in management who's not directly in that supervisory chain, but also resist the urge. And I know that there's been even some forms given out by the state that I don't love, no offense to the state, but a log where everybody fills in their name and writes down their temperature. If it's HR who's managing that, then you treat it like any other confidential information, and you're not violating HIPAA and you're not violating ADA. But if you start just handing it around to different employees, hey, fill this out and put your name underneath the other person's name, and their data is right there, that's where I think we're going to see big problems. So just make sure that you're monitoring the data, how it's logged, how it's kept, how it's destroyed, and that it's not being shared with third parties or with other coworkers.
What are the accepted reasons for an employee to decide not to come back when an employer is on payroll protection plan?
The payroll protection plan, those loans, they complicate the equation a little bit, as I'm sure you know if you have one. So if an employee, I'm not sure that how much effect that really has on what the acceptable reasons are for them not to come back. If you're talking about loan forgiveness, that's kind of the other side of the equation. So you want to, your forgiveness is based on maintaining your headcount and maintaining your payroll. So if you continue to keep your employees on the payroll and you have the right headcount and you have the right compensation amount, then that should fulfill those loan forgiveness obligations. From the employee's perspective, really the only reason that they can't come back to work should be the same reasons they could be regardless of the PPP status of the employer, and that's that they're a vulnerable individual. If for some reason they qualify for that Families First, it's important to note that if you're on Families First leave, those wages cannot be paid for by PPP proceeds. They're actually, if someone's pay is eligible for that Families First, then you can't use the loan proceeds to pay for those. But other than that, the forgiveness and the reasons for coming back are separate, and the reasons for coming back probably not affected from the employee's perspective by the PPP loan. I don't know if that answered your question, but if not, you can send another one and we'll handle it on the one we're doing later that we'll be releasing.
Yeah, we still have a lot of questions here, so let's just do one more. I am looking for confirmation of the following. HIPAA imposes obligations to safeguard protected health information, PHI, only on covered entities, which are defined to include health plans, healthcare clearinghouses, and healthcare providers. An employer acting in its capacity as an employer is not subject to HIPAA.
And that's generally true. That's generally true. That where we see the biggest issue, for example, are when and a large employer has access to healthcare data because maybe they're a healthcare provider, maybe they have some sort of medical role in that employee's life through a different piece of the business. That's where you see a lot of that HIPAA coverage. And I know that attorneys have gone back and forth in terms of the HIPAA coverage to employers. And I tend to focus less on HIPAA than I do on ADA confidentiality. If the employer has medical information about an employee, they cannot disclose it. That's what I think is more important than which law it falls under, because there are back and forth and arguments on both sides there. But in terms of practical application, if you have medical information about your employee, meaning temperatures or symptoms or any of those things or medical history, then there could be liability for you regardless of which law it's under if you disclose that to third parties, and I think, or other coworkers or whoever it is. And I think that's the primary important takeaway from all of this.
Okay, as I'm looking through these, there's so much on here on the chat. I think there might just only be one more question unless I missed something. So maybe we can just go through it now and then we don't need to record. What is the response to employees if the employer demands they not wear a mask and the employee is fearful of COVID and losing their income in a restaurant?
Sorry, could you read that again? Who's requiring the mask and who's refusing?
Sorry, so what is the response to employees if the employer demands that they not wear masks and the employee is fearful of COVID and losing their income? And I guess this was a real case in Ohio yesterday in a restaurant.
Oh, interesting. Well, in terms of the not wearing a mask in Colorado, I think there are some other issues that come into play because the Safer at Home order specifically says that you're going to be providing and requiring masks if you're employing people and you're bringing them back and you're open for business. So the only exceptions to that I'm aware of are potentially for employees who have health issues. And again, those exemptions and those exceptions are going to be primarily in the area of the accommodation. You can stay at home if you don't want to wear a mask. So if an employer is refusing to allow their employees to wear masks, then I think you might have some Safer at Home order problems, and perhaps the enforcement mechanism is through that and through the Department of Public Health in terms of how the employees should respond to that. But really, in Colorado, because of that order, that's not a situation that should be happening.